I'm Harry Arbeck in the City Attorney's Office. With me is Dan Simon, who was one of the lawyers who litigated the Joe Walsh matter. I'll start by speaking to the Bartlett appeal. Mr. Bartlett requested certain city attorney opinions through public records request. We denied the request on the basis of the attorney-client privilege, and he appealed to the district attorney. The district attorney issued an order ordering us to disclose the records on the basis of a ORS 192.495, which provides that notwithstanding any of the exemptions in the Act, all public records are disclosable if they're 25 years, after 25 years. We believe that this is contrary to our obligations under the statute that maintains attorney-client privilege. We think it will make it more difficult for us to provide you with sensitive legal advice and to get sensitive information from, candid and sensitive information from you and the folks who work for you in order for us to provide you with the legal advice and representation that is our obligation to provide. So we are asking for authorization to seek review of this through filing an action in circuit court.
Harry, you want to take questions on each separately?
Yes, whatever pleases the council.
So let me thank you for your presentation. Let me pose a concern. I'd like to get your reaction. Given the current timeline on Superfund, it is entirely likely that the Superfund process, which is the federally mandated process for addressing the cleanup of the river, will not be concluded within a 25-year time frame.
That's entirely plausible.
In fact, given that we're now, 11, 12, 13, 14 years of drift and great uncertainty about what's going to happen going forward, so it's possible that Superfund and some of the most important decisions of Superfund will not be resolved within a 25-year period. In Superfund, the city is a PRP, meaning a potentially responsible party. And there's a doctrine in the law that applies to Superfund, which is called joint and several liability. It essentially says whoever's standing at the end has to pick up the tab.
As you can see, Charlie Hales has left the
Which
building.
for a public entity puts taxpayers at particular peril. Under the ruling of the district attorney, if we're still in the midst of determining the city's share of responsibility for Superfund and determining how to allocate that share, could we be required to turn over confidential attorney-client privilege documents in which we've received legal advice from the city attorney's office about our potential liability and how we should address those issues?
Yes. The current opinion doesn't address live controversies that have gone on for 25 years, but unless we were able to convince the district attorney to change his mind, that would be true.
So I offer that as a cautionary tale because Superfund is not the only example of a federal regulatory action which goes on forever. The federal rules about reservoirs have gone on for a long time, and the city's response to them. There are other sensitive areas where, under the theory that you've presented to us, we could still be in a complex, contested proceeding where someone could successfully appeal to the district attorney to have attorney-client privilege documents turned over, even though the matter has not been resolved. So that's a concern that I have. And it does strike me that without clarification of the contours of the statute, we could be in a situation where we're forced to turn over documents that are greatly disadvantage the council, the city, and the taxpayers.
That would be true.
Sorry, I missed part of this discussion, but I just read District Attorney Underhill's letter this morning, and particularly on page 2, he cites the statute and says it's unambiguous. So if there's a need for statutory repair, maybe we should make the case that there's a need for statutory repair. But if the district attorney says this is the law on this particular subject, I guess I'm I find that fairly persuasive, and I'm not sure why we would mount an appeal for 25-year-old records, so I'm a little perplexed by this.
Well,
Mayor,
it's
this-
unfortunate you just missed the discussion
I'm
with
sorry.
Commissioner Fish because he gave it a really good reason.
Also, this technically is your resolution, Mayor. I mean, the reason is,
No, it's actually not. It came from the city attorney.
report to you.
Yeah.
And if you had a concern about this, I think as a colleague, I would appreciate a heads up about
I
that.
didn't know about it until last night.
You didn't know about a forfeit that we signed, that we had to sign?
Sorry, I didn't know.
So the issue that I have flagged for you and my colleagues is Superfund, where it's entirely possible that within the 25-year period covered by this ruling, we would have to turn over opinion letters from the city attorney's office before we've resolved the liability and allocation process. And I think that's a real problem. And as you know, Mayor, one of our frustrations with Superfund is it's going to outlive our grandchildren at the current pace. And under this ruling, even with Superfund still pending, we would have to turn over, in response to a public records request, at some point, legal opinions we got at the beginning of Superfund. So I was persuaded on that basis that it would be prudent to file an appeal just to make sure that the statutory interpretation of the district attorney, who by the way I have a lot of respect for, but has yet to be declared infallible, is addressed by a court of law. And I also think we should pursue potentially a statutory fix for the reasons that you've identified. I see it as a dual track, but if the statute, as Harry interprets it, can be read in a certain way that's different from the district attorney, I prefer to have a court decide that, particularly where we have documents that could be picked up by this ruling that would put us in a detrimental position on Superfund.
I have a different course of questions, and that's regarding your statement that there's another segment of Oregon statutes that addresses attorney-client privilege. Has attorney-client privilege ever been ruled on by the Supreme Court?
Well, frequently. The rule is a rule of evidence. Well, there's a rule of evidence. There are rules of professional conduct that require us to maintain the confidences and secrets of our clients. And the district attorney basically said that both of those gave way in this instance to that catch-all provision in the public records law that made all public records disclosable after 25 years. I am not aware of a situation in which this issue has reached the appellate courts yet. Otherwise, we would have had a clear answer.
About a public body?
Yeah.
But for other entities, attorney-client privilege?
Well, other entities aren't subject to the public records law. So in essence, what we're trying to do through this resolution is get a ruling that puts you on equal footing with private clients whose communications with their attorneys are privileged forever.
Thank you.
And can I just make a qualifying point? We get different kinds of legal memos from our attorneys. So for example, sometimes we ask them to give us a memo that just outlines the legal landscape. What are the laws, what's been the case law, and what are the boundaries that govern our decisions. I have less concern about those becoming a matter of public discussion because they don't involve the kinds of strategic decisions that we have to make in light of legal risk. A memo that says, in light of X, Y, and Z, the city might have this exposure and we recommend the following actions. No one in a complex, litigated, administrative proceeding has those legal memos put into the public record because they compromise people's positions. And if we can't get candid legal advice about the strengths and weaknesses of our case without fear of them becoming part of the public domain, then what the net effect will be there, we won't ask for them. In which case, I don't think we'll be making the same kind of wise decisions based on at least the best guidance the law or legal team can give us about legal liability. And for that reason, in that narrow instance, I think the district attorney's decision doesn't make sense. And I would prefer to have a court try to reconcile the different provisions of the statute. Commissioner Novak?
Commissioner, I have to say that I thoroughly agree with the principle that attorney-client privilege is attorney-client privilege, and I don't think that should generally be a time limit on it. But I'm just wondering what your thinking is as to that language, notwithstanding ORS 192-501, 192-505, and except as otherwise provided, et cetera, what's our argument that 192-501 to 505 does not implicitly cover attorney-client privilege?
So if you don't mind, we have able lawyers who've been briefing us on it. Harry, what's your response to that?
Well, the argument would be that the attorney-client privilege, so the public records law doesn't specify matters that are attorney-client privilege. It specifies an exemption for things that are privileged or confidential under law. And the best argument I think we're going to be able to make is that notwithstanding the public records law, the attorney-client privilege itself continues to make those communications privileged. It's not a slam dunk by any means, but we're trying to preserve our ability to give you the best legal advice we can.
When I was briefed on this, Mayor, and I don't claim any expertise on it, and as you know, we are all committed to responding in a timely way to public records. Our office bends over backwards to expedite production of documents that we can, and we believe strongly in the idea of transparent government. This question, though, about whether all privileged documents from the city attorney's office, they go beyond just advising us as the law and provide strategic advice and give us best judgment about risk in cases that are still ongoing, seems to me to present a significant challenge. And I was persuaded when Harry briefed me that we should do both. We should raise this as a question for the legislature to ponder, but we should also seek an appellate ruling so that we have clarity about where to go next.
I hear you. I guess the situation in which an issue is still ongoing 25 years later is obviously rare. Superfund, as you argue, is one of those instances. So your understanding is the law makes no distinction between legal issues that are still ongoing versus just history that for some reason somebody would want to disclose.
Harry, is that
The
right?
records that we
The statute doesn't make that distinction, that is correct.
I believe the records Mr. Bartlett wants